Okay, we will go ahead and get started as people continue to sign in.
All right. Well, good afternoon. My name is Miriam Cherry, and I'm the professor and co-director of SLU Law's William C. Wefel Center for Employment Law. On behalf of St. Louis University's School of Law, I want to thank all of you for joining us for today's webinar, The Legacy of Justice Ruth Bader Ginsburg. Before we begin, a couple of quick announcements. If you have any technical issues throughout the webinar, please be sure to email alumni@law.slu.edu. We will be monitoring that account throughout the program. Additionally, if you have questions for the panelists, please feel free to submit them using the chat function. And if your question is for a particular panelist, please do include the panelist name with your question. So we are privileged today to be joined by 4 speakers who will be reflecting on the life and lasting impact of Justice Ruth Bader Ginsburg. We're going to start with a pre-recorded video reflection from one of Justice Ginsburg's former clerks. Then we're going to hear from our 3 esteemed panelists and transition into the question and answer format of the program. So I'm going to provide a quick biography of each of the panelists. We have with us Judge Lisa Van Amburg. She's a graduate of the St. Louis University School of Law in 1975. Upon graduating, Van Amburg and 3 SLU Law classmates started their own female law firm, resolving to be private attorneys general, litigating under Title VII of the 1964 Civil Rights Act and Equal Pay Act. After practicing in the field of labor and employment law for over 27 years, which practice included successfully arguing her own client's Title VII sex discrimination case in front of the US Supreme Court, Judge Van Amburg was appointed to the trial bench in the 22nd Judicial Circuit of the City of St. Louis in 2003. She was later appointed to the Missouri Court of Appeals in 2012. She now serves as professor of practice at St. Louis University Law School. We're also joined by Professor Marcia McCormick. She is a professor of law and women and gender studies at St. Louis University. She is a member of the Wefel Center for Employment Law, and she teaches constitutional law. Her teaching and research focus on anti-discrimination and on law as a tool to achieve social equity, particularly at the intersection of separation of powers and federalism. We are also joined by Jamille Fields Allsbrook. She is the Director of Women's Health and Rights at the Center for American Progress. Prior to joining American Progress, she worked at the National Health Law Program and Planned Parenthood Federation of America, where both positions focused on the Affordable Care Act implementation and defense. Fields Allsbrook previously held a clinical position at the Harvard Center for Health Law and Policy Innovation, a teaching law clinic, and she is an adjunct professor at the University of Maryland School of Law, where she teaches a course on healthcare reform. Fields Allsbrook has a law degree with a certificate in health law studies and a Master of Public Health from St. Louis University. Our moderator for the panel today is Professor Chad Flanders. Professor Flanders has been at SLU Law beginning in 2009 and currently teaches criminal law, election law, and religion and the First Amendment. And I want to thank him for coordinating today's webinar and serving as our moderator. So many of you have seen the pictures of Justice Ginsburg's law clerks lined up on the steps of the Capitol. And for those law students who are joining us for this program, you know that a law clerk works with the judge on a day-to-day basis, researching matters of law and knows them quite well. So we are fortunate to have a remembrance of Justice Ginsburg from her former law clerk, Professor Margo Schlanger, who's the Wade and Dores McCree professor at University of Michigan Law School. Professor Schlanger wanted to be here with us today, but she was stuck in a deposition, so she sent us a recording, a 5-minute recording instead. We did have some technical issues with the sound in the first 2 minutes, so you probably would want to turn your sound up or use headphones for the first 2 minutes. So we are going to get started by playing the reflection video from Professor Schlanger, who served as Justice Ginsburg's law clerk during the 1993 to 1995 Supreme Court term.
Hi, my name's Margo Schlanger. I'm a law professor at the University of Michigan, and I had the great privilege of clerking for Justice Ruth Bader Ginsburg during her first 2 years on the Supreme Court in October terms 93 and 94. Anytime, every law clerk who worked at the Supreme Court will tell you that it was an amazing privilege and an unmatched professional experience. I got the added bonus of both A, working for Ruth Bader Ginsburg, who is an American hero, and B, working for her in her first 2 years on the court as she was figuring out what kind of a justice she wanted to be. And so I'm really pleased to join you for this webinar and just talk with you for a couple of minutes about that. Not just about my clerkship, but also about why I think that she deserves to be a great American hero. So Justice Ginsburg, as you all know, was the essential women's rights litigator. And that was part of why I really wanted to clerk for her. It was also really ever present in her, even in her first couple of terms on the court, well before she wrote the Virginia Military Institute decision, for example. So RBG's very first opinion, a concurrence, was in a case called Harris versus Forklift Systems, which is about when workplace harassment is sufficiently severe to count as a violation of Title VII of the Civil Rights Act of 1964. And way before Me Too, guided by her background as a civil rights lawyer, Justice Ginsburg understood that sexual harassment is not mere boorishness, but is a threat to equality, to gender equality in the workplace. And that understanding was what guided her to that concurring opinion where she said that sexual harassment violated Title VII if it was severe enough to interfere with a worker's ability to do her job. And that sounds pretty simple. And a few years later, it ended up being adopted by the court and became the rule that the court followed. But at the time, there were a lot of other ideas floating around. Oh, it had to be so serious that it drove the woman to seek psychiatric counseling. That was the Sixth Circuit's view, and so on. And she just saw right past that and got to the core point, which was an equality point. And I think that that's always what she did. She always got right past the stuff that was red herrings and got to the core point. And very often the core point was an equality point. And so that's a thing that I learned from her, and that it was a really important contribution that she made at the Supreme Court, a laser focus on equality as a commitment of the Constitution that makes it possible for us all to live in a democracy. So I learned that not only from that opinion, but from other opinions that she wrote and from her writing before and after that. And I think that's really the key to understanding what is so great about her, is that she really was about expanding we the people, and she really was about making sure that we are all equal under the law. And that was her guiding principle as a lawyer and as one of only 2 civil rights lawyers who's ever been on the Supreme Court, RBG and Thurgood Marshall. She brought that insight into her work as a justice, and she implemented it. She implemented it personally too. RBG had a famously egalitarian marriage with her very high-powered lawyer husband, Marty Ginsburg, who was really one of the best tax lawyers in America. And so that was also a privilege, was to kind of see what that marriage looked like and watch them in their life partnership. And that was really the personal advice that she gave all of us whenever it was relevant, was that it was really important to make sure that the person who you were married to was a life partner. I ended up meeting my husband in part because of this clerkship. It's too long a story to tell now, but the point is that he also clerked for RBG. And she was really happy about that, and that she'd had a role in making that match. I think she saw as a mitzvah, as many people in the Jewish religion do. And she was really happy about it, and she was really good to us. And I think it was really important as we were building our marriage for us to have had this example of her marriage, of this very egalitarian marriage. So the point that I want to share is that RBG was the guiding commitment of her professional life and of her personal life was a commitment to equality, and that's part of why she's such an American hero, and deservedly so. So I hope that's of some interest to you all, and have fun with the rest of the seminar. Thanks.
All right, and now we'll turn to our panelists, starting with Judge Van Amburg. Judge.
Thank you, Chad. I'm going to talk about how Justice Ginsburg affected me in my career. I attended St. Louis University Law School in 1972 through 1975, and it was during those years that Ruth Bader Ginsburg was very actively litigating on behalf of women's rights in the Supreme Court. She co-founded with the American Civil Liberties Union the Women's Rights Project, which then went on to the court with the simple argument, as Margo Schlanger said, it was a simple argument, but it was revolutionary at the time, that discrimination against women and stereotyping women into what she called pigeonholing women into certain roles was a violation of the Equal Protection Clause of the United States Constitution. And when I was in law school, the Justice Department and EEOC contributed funding to SLU Law to teach students how to litigate Title VII of the 1964 Civil Rights Act, which was the employment discrimination law passed during the Johnson administration. But in the 70s was when the litigation was just beginning. And we were aware of Ruth Bader Ginsburg's tremendous victories that she was rapidly achieving before the Supreme Court. She took 6 cases, I think it was, at the ACLU Women's Rights Project and won 5 of them. And it was an amazing thing to experience. As we were in this clinic, as we were in law school at SLU, these victories were being handed down. And it so encouraged me and 3 of my classmates to start our own law firm, to march blindly, frankly, right out of law school into federal court and file lawsuits on behalf of women and minorities and older people later. But it was the moxie that we had, I think, was bravado that we absorbed by osmosis from Ruth Bader Ginsburg. She herself had experienced in her life sex discrimination. She later decided strategically to call it gender discrimination. And that's a funny story. Somebody else can tell maybe, but I think the idea came from her secretary saying sex was too much on the minds of all those 9 male justices anyway, so just use the word gender. But she knew how to persuade them. She knew how to persuade these old white guys, and she made them understand that pigeonholing women was a harm as well to the men and their partners in life, and to families. And I think that's what was motivating me anyway to walk right into federal court. And I remember she said later that when she argued her first case before the United States Supreme Court, she was really nervous for the first 2 minutes. And then she found her stride and went on to argue the case. And this was her first case, and it was a brilliant argument that she won it. Later in the 1980s, my law partner and classmate, Mary Ann Sadeh, and I both, in the same year, argued a Title VII case, gender discrimination cases separately. It's 2 different cases in the US Supreme Court. And of course, it was our first argument. And I was so nervous, and I got up to the podium and I looked at the justices and channeled Ruth Bader Ginsburg. And the first 2 minutes were horrible, but then it fell into place. And I think today we are all channeling her because she taught us to be brave. For her personal experiences of sex discrimination were numerous. And for her, they presented this mountain to climb. For me, you know, she taught me that because I was part of the culture of the early baby boomers for whom sex discrimination was a way of life. And we were not used to challenging. Some of the discrimination that we experienced was even implicit discrimination that we didn't recognize. And it really did limit our souls growing up with that kind of culture. But she broke through that for me. And I believe for my law partners as well. And she is such an inspiration. So I hope we can all channel her from wherever she is now and continue to fight these battles that she would say tackle. And they include women's issues, but they include issues for all of us. Children's childcare, healthcare for children and families. She would say to us, I know, keep fighting and keep climbing the mountain. And so my advice to everyone, men, women, is to channel her and fight these fights, and let's make some more progress on her in honor of her service to the country.
Thank you, Judge. And now we'll turn to Marcia McCormick.
Thanks. I think I'm probably going to be sort of picking up on some of the themes from Judge Van Amburg. And you've probably heard just now, in fact, and in other contexts, stories of how Justice Ginsburg's own experience helped shape her work as a lawyer and a judge, particularly how living in Sweden and studying the Swedish legal system allowed her to see how that country supported caregiving, which allowed people of any sex or gender to flourish in ways not possible in the United States at that time. As she acknowledged repeatedly and explicitly, she stood on the shoulders of women who came before her, especially the work of Barbara Kenyon and Polly Murray. Polly Murray in particular had drawn connections between the status of Black Americans of all sexes, legally disadvantaged because of race, and women and men of all races, legally disadvantaged because of sex. These parallels shaped, in large part, the strategy of using the Equal Protection Clause to remove consideration of these classes as at least one step on the road to equality. As a litigator, Justice Ginsburg focused on cases that challenged legal rules that relied on stereotypes of women and men, as Judge Van Amburg just related. Many of these looked on the surface like they were protective of women, but they reinforced women's dependence on men and failed to support men as dependent or as caregivers. Cases she played a role in as amicus, as brief writer, or by arguing herself included challenges to rules that assumed men were better able to administer decedents' estates than women were, that men engaged in risky behavior connected to drinking while women did not, that women should only have the civil responsibility to serve on juries if they opted to do so, that men did not have caregiving responsibilities of children or older relatives, and that in married couples, men were breadwinners, and that women's financial contributions were not a part of the family's support. This work culminated, in my view, in one of the most stunning opinions, cutting right through core sex stereotypes, the kind that many take so for granted that we don't even see them. Judge Van Amburg just referred to them. And the opinion I'm referring to is one that Professor Schlanger also talked about, Justice Ginsburg's majority opinion in a case involving the Virginia Military Institute. The Virginia Military Institute was a state school for men only that used constant surveillance, conflict, and rigid hierarchical rules to create citizen soldiers. Virginia argued that the program was antithetical to femininity to such a degree that it would destroy any woman subjected to it, and that the presence of women would destroy it as well. Spoiler alert, Virginia lost. In more recent years, Justice Ginsburg was best known for her dissents. The scarf I'm wearing, this is my visual aid, now has the words of 4 of them printed on it. In these, she threw out challenges to Congress, amplified the voices of the disempowered who were not seen by the majority, calling on all of us to recognize the harm that the majority's decisions would cause real people, and reminding us of our common vulnerabilities, but differential access to protections. Even in these dissents, she was a strategist and a pragmatist, sowing the seeds for those of us to follow to build on the work. Thanks for letting me participate.
Thank you. And then we have Jamille Fields Allsbrook. Jamil?
Hi, everyone. Thank you so much for having me here. I work in Washington, D.C., frequently interacting with activists and policymakers and many other non-lawyers. And so from my vantage point, one thing I want to talk about is Justice Ginsburg, sort of how she solidified, from my opinion, her status in pop culture and as American hero, at least in part due to her ability to bring the real world impact into her legal writing. If you read some of her opinions, you don't have to be a legal scholar to find that her opinions are relatable and feel like she really understood the impact for real people. So I want to spend a little bit of time talking in terms of her legacy on the Affordable Care Act and just generally health equity, and given my own work and Justice Ginsburg status as a women's rights icon, I want to sprinkle some of that in. The ACA was decided, I was a second semester in law school there at SLU, and the court and congressional battles remain at the center of my career and public discourse 10 years later. And it doesn't seem to be letting up anytime soon. In one case, where one of the first cases where the constitutionality of the ACA was an issue in a National Federation of Independent Business v. Sebelius, the court was considering whether one of the provisions of the ACA, the minimum coverage provision, was constitutional, and whether Congress had exceeded its authority, continging federal funding on expanding Medicaid eligibility. There, Chief Justice Roberts wrote the majority opinion upholding the individual mandate, but striking down the mandatory requirement for states to expand Medicaid. And Justice Ginsburg concurred on the issue of the mandate, but dissented on Medicaid expansion. And so just putting a little of that real world sort of language into her opinion, she wrote, unlike the market for almost any other product or service, the market for medical care is one in which all individuals inevitably participate. Virtually every person residing in the United States sooner or later will visit a doctor or other healthcare professional. She then went on to say that an accident, a heart attack, or a cancer diagnosis commonly occurs without warning, and inescapably we are all at peril of needing medical care without a moment's notice. And the simplicity and relatability of those words to me are something that I think that can resonate with us all and really have even more of a meaning now in light of her passing. And, whether or not people ultimately agree with her legal conclusion, I think you can understand and relate to those words. A few years later in King v. Burwell, when the fate of the ACA was again on the line, particularly whether it was permissible for premium tax credits to be available in states that have not set up its own marketplaces. Just for context, for those who aren't familiar with the case, an adverse decision here would have unraveled a core piece of the ACA. And given at the time, the vast majority of states hadn't created their own marketplace, and still only 32 states still rely on the federal marketplace, and the majority, 86% of people receive tax credits, it would have essentially unraveled the law. And Justice Ginsburg there joined the majority to uphold the provisions. These decisions and subsequently Justice Ginsburg's votes to uphold the ACA, just stepping a little out of the legal writing to the real world impact it have on health equity, particularly for low income people, people of color, people living in rural areas, and women. Health insurance status, as well as the quality of coverage a person has, can serve as a barrier to care, and ultimately, as we're seeing right now in the midst of a health crisis, can mean life or death. You know, Blacks and Latinas, and particularly, and particularly women, are more likely to forgo or delay care due to costs, and less able to withstand unexpected medical costs. And the ACA, with the great lengths through expanding coverage to 20 million people, improving the quality of coverage, consumer protections, including prohibitions against charging women more for coverage, doing a long way for health equity. And so we will soon see what Justice Ginsburg's absence from the court means for the fate of the law. The court has arguments scheduled on November 10th about to decide the constitutionality of the law and whether or not those benefits I mentioned would stand. I want to also talk a little bit about Justice Ginsburg's writings as it relates to an often litigated provision of the ACA, which is the birth control benefit that has led to 61 million women having birth control coverage with no out-of-pocket costs. Justice Ginsburg frequently highlighted her famous dissenting skills, those that inspired some of us to have T-shirts that says "I dissent." In some of these cases. So for example, in Hobby Lobby v. Burwell, the court ruled that a for-profit corporation was entitled to a religious accommodation from the birth control requirement. And there, Justice Ginsburg dissented, writing, "In the court's view, the Religious Freedom and Restoration Act demands accommodation of a for-profit corporation's religious beliefs, no matter the impact that accommodation may have on third parties who do not share the corporation owner's religious faith." And then she went on to quote Planned Parenthood v. Casey, stating, "The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives." And just in June, in arguments that were in a decision where the arguments have reportedly been held while she was in the hospital, Justice Ginsburg, again, in the case, and two combined cases, Trump v. Pennsylvania and Little Sisters of the Poor, dissented from the court's ruling to uphold broad religious and moral exemptions related to the birth control benefit. There she stated, "This court leaves women workers to fend for themselves, to seek contraceptive coverage from sources other than their employers, insurers, and absent another source of funding, to pay for services out of their own pockets." And she went on to say, "Lacking any alternative insurance coverage mechanism, the exemption leaves women with two options, and neither are satisfactory." And I highlight this language just to show you that even in the dissent, her words were echoed and impacted many of us, and frequently served as a rallying cry for people to try to make culture change even outside of the courtroom. Even when she was on the losing end of the argument. And so, you know, it's worth noting that, you know, these cases, particularly around reproductive rights, will be before the court again, without doubt. And as much commentary talked about this week, the fate of some of those rights, including birth control benefit and abortion rights, is even more uncertain without the Justice Ginsburg on the court.
Thank you. All right, so we have some questions for our panelists. And so I think we have one for the judge. Judge, can you talk about the influence, if any, of Ginsburg on your judging? So you talked about her influence as a litigator. Did she have any impact with you on the bench?
Yes. You mean in her role as a justice? Yes. She was a very soft-spoken person, and you know, on a bench where men dominated the discussion, it seemed to me that she always got a chance to pipe in her opinion, and everybody quieted down and listened to her. And what I learned from her is that you don't have to be, you know, if you choose your words carefully. And also, she spoke very slowly, just like that, you know. And so I think a lot of a lot of women don't feel listened to in a group. You have to kind of barge in and be loud or be fast with what you say. But she taught me a different way of being heard. And so in my role as an appellate judge, I did evolve in the way I handled oral arguments, and tried not to, jump in and out of my turn, and try to wait for my turn, and then to make it count what I asked or what I said in a polite, persuasive way.
Thanks. And we had a question for Marcia. So Marcia, you talked about the influence of Ginsburg's dissent. Could you talk about the Lilly Ledbetter case and her dissent in that case?
Yeah, so that's one of my favorites, actually. I was asked recently in another context what my favorite Ginsburg opinions were. And as I mentioned, my favorite majority opinion is the VMI case, but my favorite dissent is in Ledbetter. And so the Ledbetter case involved the question of when discrimination happens. Lilly Ledbetter had worked for many, many years at a Goodyear plant in Alabama, Gadsden, Alabama. And there had been a decision made fairly early in her tenure there that she should get paid less because she was a woman. She didn't know about this until right before she retired. And she couldn't really bring the suit until she retired because she had suffered retaliation for complaining about discrimination. And so the issue before the Supreme Court was, when did the discrimination happen for purposes of when she could file suit? If the discrimination happened every time she received a paycheck, her suit was timely. But if the discrimination happened way back when she didn't even know that discrimination had happened, then she was out of luck a long time ago. And the Supreme Court decided, the majority decided, that it happened, the discrimination, when she didn't even know about it, and that she was out of luck. Justice Ginsburg's dissent pointed out the challenges of that approach, the continuing effects of discriminatory decisions with each paycheck, and the best is the last line, where, of course, the whole point of interpreting a statute, most judges agree, is to give effect to what Congress said and what Congress meant to do with that language. And Justice Ginsburg had spent a lot of time showing why Congress had meant that Lilly Ledbetter's suit was timely. And so her very last line was a challenge to Congress, saying the ball is now in Congress's court to right this wrong, essentially. And not very long after, Congress did pass the Lilly Ledbetter Act of 2009. It was the first legislation that President Obama signed upon taking office.
And Jamil, we got several questions for you. I'm going to sort of paraphrase all of them. They're asking you to sort of predict, what is the court going to be like without Justice Ginsburg? Like what things are going to change? A few panelists have noticed she was dissenting a lot, but what's the future court sort of look like without Justice Ginsburg as part of it?
I mean, that is the most one of the most asked questions here over this past week, and of course, the short answer depends on who gets put on the court to replace. I think so. We know that there is a process going on now, and we could see a nominee as soon as tomorrow. And the short list of people that could potentially replace Justice Ginsburg. Many of them have expressed opposition to abortion rights. One of the leading contenders, Judge Barrett, also has some public opinions opposing birth control access, including commenting on the ACA birth control benefit that I just mentioned. So, of course, it'll depend on the person. But President Trump, even before he was president, when he was a nominee, noted that his goal was to put only pro-life judges on the bench. And so whoever the person is, we can make an assumption that he's going to keep that promise, and that will shift the court to be more of a 6-3 conservative. So, the less a wonky answer way of saying that, I think we can make a guess that reproductive rights, abortion rights will change, and how that will look. It's been, hotly talked about and debated. The right to abortion that has already been restricted in many ways, and there's been numerous restrictions through the law. As someone I saw mentioned, Justice Ginsburg was often in the dissent, so that's not a new thing. That will continue to happen, but if the court shifts even more conservative leaning, I think we could definitely expect even more chipping away at the right to abortion. I know there's been a lot of news articles, saying that the future of Roe v. Wade is at stake, and sort of reproductive rights advocates have been saying that for a while, and so people might bat their eyes and think, we've been saying that, and it's probably not going to happen. But I think if ever there was a real threat, it is true right now. There's over 20 states, I think, have trigger laws, which is that if the Supreme Court were to overturn Roe v. Wade, then there would be, they would automatically ban abortion in their state. And so whether or not that actually happens, and it likely won't happen perhaps right away, we can definitely expect that some of those rights will change, and the form of them will change.
Marcia or Judge, do you want to have any thoughts on that question?
I think what happens to the Affordable Care Act will impact women dramatically. As it is now, women who are home with children during the pandemic are the ones, if somebody had to choose the husband or the wife or the partner, male partner or the female partner, because of pay discrimination, it's mostly the women staying with the kids who aren't in school, because they don't get the higher salary in the family. So they're home, and there's going to be a huge setback for women in their careers. And now with the Affordable Care Act on the line, with the new Supreme Court, I think women are going to have to deal with 3 or 4 steps backward from where Justice Ginsburg left us, just because of the pandemic, and then the impact on healthcare. Doesn't matter who's on the court if they strike down the ACA. In other words, it's going to be bad for women for sure, and children.
Marcia?
Yeah, so I think I'd sort of hearken us back to something that that Professor Schlanger noted, and that is Justice Ginsburg's focus on equality as sort of the core underlying thread of her jurisprudence. And so we think about the Affordable Care Act as not about equality necessarily, but about support in general, and about people's ability to afford healthcare. But that is an equality issue, and it's an important equality issue that's being lost, I think, without Justice Ginsburg's voice. She was much better able than a lot of jurists to explain the way that government supports our actual inequality issue. The way that we structure society is a way that we enable people to thrive. And so I think that without her voice on the court, that approach to the Affordable Care Act and its benefits is lost.
Thanks. So I have a question, and Jamil touched on this in, I thought, a great way, but about Ruth Bader Ginsburg's sort of celebrity status. And I think one part of that, I think Jamil pointed out, was she wrote in clear prose and was accessible and could, but is there anything more to that? It seems like she became sort of like almost a cult figure. So what went into her seemingly enormous celebrity? Does anyone want to comment on that?
She was a great storyteller, and she had an ability to entertain people. She was very funny too, and she had funny stories to tell, and people wanted to hear them, but they all had a purpose. Every story she told had a persuasive value. And she would tell funny stories about, for example, funny stories that would burst your stereotyping. And she would say, Well, you know, this theme that Professor McCormick raised about her persuasiveness was in part based upon a tactic of arguing that equal rights for women would enhance the lifestyles of all families and husbands and children. And when she was, I guess she had two small children when she was an advocate before she became a Supreme Court justice, she got a call from the school complaining about her son's behavior and saying, you know, they wanted her to come in and discuss her son's behavior with them. And her response was, my son has two parents. It's, you know, my husband and I alternate dealing with your calls, because apparently the son was a little bit of a behavior issue. Call my husband. Now, I got those calls from school. I never thought to say, call my husband. You know, that's what I'm talking about. She was so good at identifying the sexist culture and challenging it right in the moment. And then she could make people laugh about it. When she told that story, everybody laughed. But she was an entertainer and a storyteller.
Yeah, I mean, and the only thing I'll just chime in and say that one thing, and this is probably just my own personal reflection, I just always found to be just very much a straight shooter, as sort of my mother would say. And I felt like that whether I heard her speak or whether or not in the opinion. So again, I think that some of the best ones favored are the dissents, and sort of, and one of them, back to Marcia's point, about the impact related to the ACA, she sort of shides the majority, saying, like, you spend hardly any time talking about women, like you haven't even considered it. It's not that you considered it and ruled differently, you just didn't even consider it. And I think that that may, for people to be able to really relate to that, I think people, like I said, people who were non-lawyers took her opinions and cited them and tweeted them and sort of upped the profile in a way that you just don't see frequently, in addition to, and not to undermine, of course, sort of the underlying legal arguments she would go on to make, but it definitely was able to elevate it to a status for even those who of us who are lawyers could appreciate that.
Yeah, I think part of it too is that she was a tiny little person who had an outsized personality that you did not expect. And her forthrightness in combination with that, plus her workout program, I mean, come on. All of those things made her a visible representation of some stereotype breaking that all of us kind of can relate to and find appealing.
So there's, we've got a lot of paragraph long questions that I'm trying to read as I listen. But one commenter referenced the line about having 9 women on the Supreme Court. I wonder if one of you could touch on the role of having women on the Supreme Court. So now we've had Sandra Day O'Connor, Justice Sotomayor, Justice Kagan, Ruth Bader Ginsburg. How important is it to have women? And the quote referred to is, there'll be enough women on the bench when there's 9. What if one of you could speak to the role of women on the Supreme Court?
Well, I'm hesitating because I don't want to stereotype women, and I'm not sure about that. All the women there hasn't been let's just say the scientists say there hasn't been a fair sample, because there's been so few women on the Supreme Court, to be able to gauge how an all-female Supreme Court would act. There will be differences of opinion. There will be women on that court who have lived with gender discrimination themselves, but have never identified it or felt willing to challenge it. There will be women on the court who have had different experiences with I guess, Sonia Sotomayor's experience of being a person of color and a woman, you know, so all of the variety of human experiences, but women have all uniformly experienced discrimination. So I have to be hopeful that, you know, a more female tilted Supreme Court would be more sensitive to all forms of discrimination. But that's a hope. I don't think we have enough data to generalize.
Yeah, and I'll just say, I mean, I think that to the judge's point, I do think that there is a certain experience that goes, a lived experience that just sort of by just living, and especially living in the US, being a woman, including interacting with having maybe experienced discrimination or learning to navigate that most women would bring to the courts, and I would like to think would you know, sort of bring that perspective when looking at like decisions. But of course, we know that all women are not interchangeable, and that from my perspective, many of the things that Justice Ginsburg, her fight for equality, by nature of just being a woman, doesn't necessarily guarantee that would bring that perspective to the court. Though, you know, I would always be supportive of a more woman-centered Supreme Court, as well as also having different perspectives of people of color, including women of color, having gender non-binary people, trans people. All of that would bring a different level of experience and diversity to the court. And I think, would bring, especially when you're talking about civil rights decisions or LGBTQ equality and otherwise.
Yeah, I view that her comment actually a little bit differently. Not as the Supreme Court would be better if it had 9 women, but it certainly wouldn't be worse, right? And for so much of our history, we thought that, you know, there was no problem. I'm using the you know, collective we here, going back in time, but people didn't think it was a problem to only have men do this stuff. And so why not? If really we are an egalitarian society, then it's just as likely we would have a period of history where 9 women were on the Supreme Court. And ultimately that shouldn't really, that shouldn't result in any worse outcomes.
And there's a comment that I kind of want to expand on and I'll end, we have a few minutes, but I want to end on sort of so we're about to enter into a confirmation, possibly a confirmation battle. Is it a good thing in a democracy to have so much emphasis placed on the Supreme Court and who's the next Supreme Court justice? Or is this something we should be worried about? I know that's a broad question, so I'll leave it open to anyone who wants to tackle it. Which may be no one. Marcia. I
have really conflicted views on this because on the one hand, in our system, I am sympathetic or acculturated to the idea of judicial supremacy that requires independence of the judicial branch, and in a way to protect political minorities from tyranny of the majority. At the same time, at least right now, it feels like every single thing, so much is at stake. Like the fate of the universe hinges on every decision right now. That's how it feels. That may not be accurate, but I think we're all sort of experiencing that right now. And that I don't think is healthy. And so I don't know what to do with that. I'm feeling both things at once. And so I haven't figured out a way through yet.
Yeah, and I'll just answer quickly because I know we're at time. I mean, I think to your question, it should so much be focused. I'll give the short answer. I don't think so. No, it would be my answer. I think in an ideal world, we would have 3 equal branches, strong branches, and that we would just rely on the Supreme Court. Congress would also function, and we would have sort of a balance. And that it wouldn't feel so much like many people felt after the passing of Justice Ginsburg, or at times when she was sick, people felt very much like, you know, the fate of our democracy is in the hands of this one person. And I just don't think that's healthy, especially for the most disadvantaged people in our society, which tend to be lower income people, Black people, Latino people, and others.
All right. Well, unfortunately, it looks as if we've reached the end of our time together today, but I really want to take a moment just to thank our panelists, our wonderful panelists, for taking the time to share their expertise with all of us. It's been extremely insightful, timely, and I have found it personally meaningful. And I want to thank our audience who had joined us today. We hope that you enjoyed the panel. We're going to be following up with an email and with a survey for your feedback on the program. So again, thank you all for joining us, and we hope you have a great rest of your day.